Welcome to the Salt Marsh. We're here with Arthur
Well
Bergeron from Mirick O'Connell talking about elder law for couples.
Well, thank you very much.
Alrighty,
thank you very
enjoy.
much to the folks at the Salt Marsh for inviting me back here. Thank you for coming to, this is the first presentation of the 2019 series. For those of you who don't know me, my name is Arthur Bergeron. I work at a firm called Mirick O'Connell. There are 70 of us. I found out we're actually the largest firm in Massachusetts outside of Boston. It's not centered in Boston. So because there are so many of us, everybody gets to do what they like. And so I do this. I do nothing but elder law. I like it because most of my clients think I'm still young, which is terrific. So what I try to do every year is do 2 presentations in the spring, 2 in the fall. The ones in the spring are more kind of general interest, and then the ones in the fall are more specific topics. This is the first one, which is elder law for couples. The next one will be elder law for singles. Every time I come here, I think I should remember to find out the date of the next one so I can say that, but I forgot. So I don't know when it is, but it's coming. Check the calendar at the Salt Marsh, and they'll tell you. So if you haven't been here before, these are my friends Frank and Mary. I always talk about them. Frank and Mary and their kids. Can we cut for a second? Oh, we're back. So we stopped for a second for a technical problem, and in the meantime, my friend Laura Stewart found out that the next presentation, the Elder Law for Singles, is on April 25th. That'll be a Thursday, April 25th. So I always talk about my friends, Frank and Mary and their kids, Peter, Paul, and Mary Jr., and the goal of their life is to live in their house until they die and to avoid and to leave everything to their spouse, and then if their spouse has died, to leave everything to their kids. This is not an uncommon basic estate plan. So in this presentation, I decided that what I would do is change it a little bit in order to really talk about Frank and Mary at 2 different times in their lives. Frank and Mary at 65, and then I'm going to talk about Frank and Mary a little later at 80. Because the issues that they have are a little different in those 2 different times. So if you're Frank and Mary and you're 65, then your issues are really 3. You've got issues about, or you should be worried about this. What happens if I just get sick or I have a stroke? Something I'm going to be out of commission for a while. Who's going to take care of things for me? The second that a lot of folks talk about is if something happens, I don't want to have to go through the probate process because I think it wastes a lot of time and money, which it does, unless you need it for other reasons. And then third, how do I make sure that I can minimize any estate tax that might be owed if I have assets that exceed $1 million in value, which here in Nantucket, that's a lot of people because of the house. So we're going to talk about all of those things. So once again, if your issue is simply short-term incapacity and how to deal with it, you need 2 things and 2 things only. And you have to have these. Everybody should have them, but you get to our age and you have to have them because the chances of something going south for a while are much higher. So the 2 things are your healthcare proxy and your power of attorney. Your healthcare proxy, you need to have 2 witnesses, and the only person that cannot be a witness is the person that you're naming as the proxy. It can be their spouse. It can be any of your kids. Doesn't make any difference, okay? The healthcare proxy only kicks in if you are incapacitated. What that means is if your doctor has said in writing that you are unable to make a medical decision, that's when your healthcare proxy kicks in. You can only name 1 agent at a time. So in your proxy, you can't name 2 of your kids, right? Only 1, because if I'm the doctor and you're sick and I don't want to talk to 2 of your kids and having them arguing about what to do. I only want to talk to 1 at a time. So 1 at a time. And you can revoke your proxy at any time, and doing a new proxy automatically revokes all of the old ones. So if you ever went to the hospital and you're in the emergency room and you hadn't brought your proxy with you, and so they brought you the form out and they said, we really want you to sign this proxy while you're at the hospital, and you signed it, and then you got discharged, they probably threw it away, that proxy, and by signing that one, you also revoked all of your old ones. So if you had one at home, technically it got revoked during that time. Now, so the moral of that story is, where do you put your proxy? You probably want to keep it with your doctor, and I'm going to talk about that a little bit more. But I want to mention this because we're going to be working more on this, I think, as this year goes on here in Nantucket. And that is, in addition to having a proxy, you have to do some other things. First, you have to tell your proxy that they're the proxy. If you talk to the folks at the hospital, they'll tell you that maybe 1 out of 5 people that they call because someone's at the hospital and they need to talk to the proxy will say, I'm the proxy. So you want to tell the proxy. Second, you want to have a conversation with the proxy about how you actually want to be treated if there's some kind of an emergency. And I know people tend to think about this as if the conversation is really about, what am I doing in the last day before I die? Or don't resuscitate me? Or that's not the conversation. The conversation is, suppose you're going to be sick for quite a while. And so the proxy really has to make a whole series of decisions. Suppose, and I often use this example, suppose you had a stroke. And now as a result of that stroke, suddenly you can't be making your medical decisions. Or even if you can't be, you're having trouble communicating them. And, and that's going to be your condition forever, the doctors say. And then you get pneumonia. And so the question is, you're living at home, you got a lot of other stuff there to take care of you. You're living at home, you get pneumonia, and the question is, do you want to go to the hospital? Because of course, if you go to the hospital, they'll cure the pneumonia. Now, when you get back home, you're still going to be the same conditions as you had with the stroke, but the pneumonia will be gone. So the question is, in that case, do you really want to go to the hospital? So one of the things you want to talk to your proxy about is, what are the things to you about life that make you feel that, if you didn't have those things, the proxy shouldn't be going through killing themselves to keep you alive, right? So these are the kinds of things you want to have that conversation. There are questions like this that are brought up in this form called the 5 wishes. I'm not a big fan of the 5 wishes because that document is really designed for, once again, people who are really at end of life, as opposed to these kinds of broader questions. These questions are raised through another program called Honoring Choices. I was speaking to a set of folks here in Nantucket. I think we really want to be working on an initiative kind of later this year to try to encourage people to do this more, so kind of stay tuned. But regarding your healthcare proxy, your first question is, where is it? Raise your hand if you have a healthcare proxy. Most people. Raise your hand if you know where it is. Oh, well, that's good. Most people do. A lot of people don't. The point about a healthcare proxy is it's going to be used a lot of times when there's an emergency. People are running around looking for stuff. You want to make sure you know where it is. Probably the best place to have it is in your doctor. Your doctor, under the state healthcare proxy law, is required, if you give him your proxy, to put it as part of your medical record. And if you go to the hospital, this makes it nice and easy. You never have to find your healthcare proxy. Your doctor's going to email them the healthcare proxy, right? And there's always going to be kind of where so that you know where it is. Once again, if you think it's at the hospital because you signed one of these before, you're probably wrong. It probably is not. Power of attorney. No witnesses are required for a power of attorney. And as long as that attorney, the purpose of a power of attorney is to allow someone to do all of the legal things that you can do. Sign your checks, sign a deed, deal with other bank accounts, do anything, talk to your insurance company. And that person kind of replaces you. But the power of attorney, when you sign one, doesn't cause you to lose any power. It just says that in addition to you having the power to do all of these things, this other person also does, right? So you can name, and the only time that you need witnesses for that is if you own property that's out of state. Massachusetts, you don't need it. For example, though, New Hampshire, Maine, and Florida, which are 3 states where often people have property, you do need witnesses. You don't need notarization for a power of attorney. But it's preferred, and the reason for that is that most people who see a power of attorney, if you're at the bank or your insurance company or whatever, think that by virtue of something being notarized, it becomes like an official document. So the only reason why you're getting the document notarized is so people will think it's official. It doesn't really make it official, but the point is, if you want to make sure the bank person will accept it, it's a good idea to have a notarization. You can name in your power of attorney more than one person, and you can name them to act, if you want, jointly and severally, which means if you've named several people, your spouse and one of your kids, or 2 of your kids, if either one of them isn't around, the other one can do it. It doesn't mean they both have to do it, they both have to sign off at the same time. And in the power of attorney case, a new one doesn't revoke an old one. So you can have a bunch of powers of attorney out to a bunch of different people. And the reason why I mention this is if you're in that situation, which I've found clients in, where you gave a power of attorney to one person and then you're starting to say, nah, I don't think I want that person anymore. I'm kind of not trusting that person. So you want to name somebody else, and you do. Well, in order for you to cause the first power of attorney to go away, you have to revoke it. You have to notify that person that it's revoked. And what you also really have to do is go to anybody where that power of attorney, where that person might go, and tell them that you revoked it. Because if that person goes into your bank, say, with your power of attorney, chances are that power of attorney has a clause in it that says that if I'm the teller at the bank and this person gives me a power of attorney and gives me a sworn statement, probably notarized, right, that says that the power of attorney has not been revoked and that you're not dead, I'm going to give them all the money. Because that clause says that if I do that, I'm not liable, as long as I've got the power of attorney and this affidavit. So the only way that that bank teller would be liable is if you had gone to that bank and done something in writing and given it to the bank saying you revoked that power of attorney. So it doesn't come up a lot, but it's the kind of thing you should be aware of. Other things that you should look at, if you have a power of attorney, raise your hand if you have a power of attorney. Raise your hand. A few people do. If you have a power of attorney, for purpose, as you're getting older, you may want to kind of look to make sure that these three things are in there. One, if you have real estate, you want to make sure that a provision is in there specifically allowing your attorney to sign deeds and other real estate related documents. That can be really important, especially I find that's important when I'm dealing with nursing home cases, with cases where I've got someone who has become incapacitated, so we need to be moving assets around, and often that asset is the house. And so I need to have the house often transferred typically from the two spouses to the one who is healthy, which means someone has to sign on behalf of the spouse who is sick, which means there needs to be a power of attorney. And the power of attorney typically is the spouse. That power of attorney has to say specifically that that person can sign that deed. Also, gifting. You need to make sure that your power of attorney says, if you wanted to, that the person you've named can make gifts, especially gifts to himself or herself. Same issue. One spouse needs to qualify for mass health. We need to move assets around from the sick spouse to the well spouse. The well spouse typically is the agent under the power of attorney, but unless the power of attorney specifically says that the agent can transfer things to himself or herself, we can't do it. We can't do it. So it's really a problem. Third, if you have an older power of attorney, look to see if it has a provision that limits the amount of gifting. Many of the older powers of attorney, which were done by attorneys who were focusing on tax issues, estate tax and gift tax issues, will have a ceiling on the amount that can be given. And the ceiling usually refers to the maximum amount allowable under the federal gift tax law, which is now $15,000. That's really problematic if we need to be moving assets around and in an amount of more than $15,000. So there are some provisions you want to look at to make sure your power of attorney has them. Estate planning. When these folks are coming in, we're talking about what they want to do, and typically they'll say, well, if one of us dies, I want to leave everything to my spouse. And after that, I want to leave everything to the kids. And that all works great. And by the way, to have that happen in Massachusetts, if you're Frank and Mary, and these are your kids, this wasn't a blended family, then you don't even need a will to do all of that. Because that's exactly what happens without a will. If you die owning something in Massachusetts and you have a spouse and kids, everything goes to your spouse. I knew that was going to happen. No, that's actually my phone. I'm going to let that go, and then I'm going to go shut it off. So, and then if you die and your spouse is still alive, everything simply gets divided up among the kids. So the exact same thing happens if you have a power of attorney, or excuse me, if you have a will as if you don't have a will. And in either case, all of those things have to go through the probate process. So having a will does not allow you to avoid the probate process. But when you're thinking about, so the question is this what you want to have happen? Do you want to say that if your spouse has died, all of your assets are going to simply go to your kids? And when you're thinking about that, you want to ask these three questions. Does any of your kids have creditor problems? Does any of your kids have spouse problems? Is any of your kids disabled or have a disability that might require them or where they might want to qualify for government benefits? In any of those cases, you may not want to say in your will that you're leaving those assets to that child. Because if you leave it to a child that's got a creditor problem, the creditors can get it. If you leave it to the one that, who's married to the daughter-in-law or son-in-law that you never liked in the first place and you worry about a divorce, in the case of a divorce, that money is going to be in play. And if you have a child who has a disability, giving him money may very well cause him to be disqualified from the government benefits program like Mass Health as a result of that disability. In all of those cases, what you probably want to do is leave assets in trust for the benefit of that child. In the case of Frank and Mary, where you have several children, what you would typically do is say that one of the other children would be a trustee for the benefit of that child who may have a problem. Because as long as the child who may have a problem does not have the legal right to order that money be distributed to him or her, a creditor can't get to it, the spouse can't count it, and it doesn't get counted if that child needs to qualify for a disability program, which is means tested, like Mass Health. Okay? Other issues that come up regarding that kind of estate planning. So if you're doing, who's going to manage all of these for you, right? Whether you're putting things into a trust or whether you've got a will, who's going to be the manager, the personal representative or the trustee? Just a couple of things. Obviously, you're going to put a trusted child. Oftentimes, people will name more than one of their children. And I just always tell people, you never want to structure an estate plan that could end up in a tie, ever a tie, right? So if you're naming more than one person, and it's an even number, make sure you name a tiebreaker. As I've often mentioned, I often get named in that role. I have probably been named as a tiebreaker 500-600 times. I've never been asked to break a tie, because as soon as people realize they have to pay the tiebreaker, they figure it out. So you always want to have a tiebreaker. You want to be clear if you're dealing with personal property as opposed to dealing with money, which is easy to divide up. Who gets what? You want to be specific about that. If your goal is to say, when you die, all of your assets are going to be divided equally among your kids, and one of the assets is a house, then you may want to say right in the will, my goal is that the house will get sold and the proceeds will get divided among the kids. Unless you really want to give the house to the kids, because if it just says everything gets divided three ways, that means the house goes to all three kids. And now you got a house with three owners, and now what do you do? Especially if like one of them is living there and the other two want to sell it, or one of them thinks it's worth $1 million, the other one thinks it's worth $250. And you're trying to figure that out. And everybody's got, in that case, a veto because all three of them own it. So in that case, you'd want to say in your will or in your trust, I want my house to be sold and the proceeds to be divided. You want to structure things so that there are no appraisals. These inevitably cause problems. If you want to leave your house to your child or give one child the right to buy out the other child or any of those things, you want to try to, if you can, put in a number which is going to be the basis of all those decisions. Most common number is the assessed value of the property at the date of death, which isn't exactly right. But of course, no number is exactly right, because the right number is the amount that somebody would really buy the house for, and who knows what that is. So that way, nobody's fighting about that. Because of course, whenever you have the ability to buy a property, the price that's being offered is always too high. And whenever you're selling, the amount that's being offered is always too low. And that's just the way it goes. So you want to avoid that by figuring out a number. I talked about house occupancy. If you want to have one of your children continue to live in the property, you want to put real clarity into that. Like, they can stay in the property as long as they pay all the bills, and exactly what bills are those. And as long as they don't have other people there. Can other people move in? What if they move out? Can they collect rent on the property? You want to be really kind of thinking all of that out, okay? And finally, grandchildren. I'll just mention one thing. Many people will say, well, I really want to leave the money to my grandchildren to pay for their college education. And as I try to emphasize, in that case, what you may have just done is instead of leaving it to your grandchild, you really left it to Harvard, right? Because Harvard is going to subtract those dollars, dollar for dollar, from what Harvard's going to give them in terms of tuition and loan money. Whereas if you give the money to the parents, while the parents' assets are taken into account in looking at what the child gets, oftentimes the value of those, they'll look at the number that I've always heard was like 5 to 1, that in those cases, for every $5 the parent has, they figure that the parent can afford to pay $1 to the school. So you may want to kind of watch out for that one. Probate avoidance. Suppose whatever you want to do, you want to try to structure things to avoid the probate process. Now, why would you want to do that? Well, to understand that, you need to understand what probate is. The point of probate is it only affects assets that are just owned by you individually at the time of your death, not assets that are owned by you jointly with someone else. Because if you own an asset jointly, then legally you each own 100% of that asset. It's a tough concept, right? But it's true. And legally what happens, one person dies, their interest simply evaporates. The other person then owns 100% of the asset, right? So any assets that are held jointly, or any assets like oftentimes annuities or stock accounts, many kinds of accounts will allow you to name a death beneficiary for those assets, a pay on death, POD, or a transfer on death, TOD. In all of those cases, those assets upon your death don't go through probate because it's clear who gets them, right? So the only assets are the assets that go through, that you're just in your name. So the purpose of probate at that point, once you're dead, is to figure out who gets them, who gets what. And as I mentioned, if you don't have a will, there's a formula for that. The state has written a will for you, basically. If you do have a will, it's whatever your will says, right? But the point is that there's another purpose to probate, and that is to make sure the creditors get paid. All creditors of yours need to get paid from the probate estate before the rest gets distributed. And creditors have 1 year from the day of your death to file a claim, which is why probate always takes a year. It takes at least a year, because you have to wait until the end of that year to make sure there are no claims. And you will always say, but I don't have any creditors. And I will tell you, but that doesn't make any difference. The point is, you can't just say that. Oh, you go to the court and you say, well, I don't have any creditors, so I don't want to wait the year. And the judge says, well, no. The point is to see if anybody shows up, because you don't know if you don't have any creditors. You know, what about that guy that you ran over before you died, you know, who hasn't filed his claim yet for all the injury that you caused them? You know, you don't know that. So that's why probate always takes a year and is always subject to the claims of creditors, which is why some folks will look to try to avoid that. I'll just mention a couple of other specific things. Cars. If you're married, you're Frank and Mary, and you own a car and it's just in your name, there is a special state statute that says that in that case it is presumed that the surviving spouse was a joint tenant. So if one of you dies, the other person can go to the registry with the title and a marriage certificate and a death certificate, and the car automatically can get transferred to you. Tangible personal property, the stuff that's like around the house, is presumed in law to be jointly owned, even if you don't have any bills of sale or any of that jazz. So once again, this issue never comes up in the case of Frank and Mary. It actually very seldom comes up in the case of the kids. If you die and all you've got is tangible stuff around the house, then you don't have to worry about it going through probate. The kids are just going to divide it up. And the reason is they don't really need to go through probate. They don't need anything from probate. If you died and you had no spouse and you said the car, you would need to go through probate because a car has a title. And somebody needs to get a new title if you die. And the only way to do that is to go through probate. So that's the point of probate, is to find out who owns what. Wills do not avoid probate. At least once a month, I'll have somebody tell me they've got a will, so they're not worried about probate. Wills do not avoid probate. Wills simply tell the person who's running this process, after the year has gone by, where to give things to, right? And you want to avoid it both because of that 1 year delay, and you don't want to pay me or someone that looks like me $3,000 to $10,000 to get through this probate process. That's about what it's going to cost. So as a quick quiz, if you're Frank and Mary and you have these assets, you got a house, and I forgot to put that the house is jointly owned. Frank has an IRA or a 401k worth about $300,000. There's joint savings of about $200,000. Frank has an annuity that he had bought. but Mary's named as the beneficiary. Mary has savings of $50,000. So total assets are $1,100,000. If Frank dies, does this have to go through probate? Raise your hand if you think it does. Raise your hand if you think it doesn't. I got one person who says it doesn't. You're the winner. It does not have to go through probate. The house, if it's jointly owned and Frank dies, instantly becomes Mary's. Frank's IRA or 401k, you always list death beneficiaries for those. So that's going to pass right through. The joint savings, same thing, jointly owned, automatically goes to Mary. Frank's annuity, he's named Mary as the beneficiary, and Mary's savings are Mary's savings, right? Still hers, even though he's dead. So there is no probate in that case. So often, when you're thinking about whether you want to avoid probate or need to, this is the way to do it. Just go asset by asset and say to yourself, is it clear now, if I die, where that asset's going to go, right? So the mechanisms for avoiding probate, we just talked about two of them. One of them, joint ownership. If you own something jointly with somebody, as Frank and Mary own a lot of stuff jointly, you don't need probate. If the assets have a transfer on death or a pay on death provision to them, like all IRAs and 401ks, or stock accounts, Fidelity, a lot of these companies have pay on death provisions, then that asset won't go through probate. Unless, by the way, you name somebody who's dead. I often have this happen with an older couple. They'll have an insurance policy or an account or whatever, and one spouse dies, and then the other spouse dies. And the first and the second spouse had named the first spouse as the beneficiary, which means there's no beneficiary. Those assets revert then to the probate estate of that second person who died. I'm going to talk about trust in a second, but I also want to emphasize what very few people do, which is last-minute gifting. So suppose you're Frank and Mary and you got all those assets, right? Or suppose that you're just Mary because Frank is dead and she's got all those assets, and she's really sick. And she knows that if she dies owning all those assets, there's going to be probate, there's going to be all this stuff. One thing that she could do is, remember, in that case, we're saying she's got a power of attorney because she went to one of my presentations, so she has a power of attorney. So she could just tell the person with the power of attorney, who is typically a child, ahead of time, if I get really sick, you know how everything gets distributed. Here's the will, right? We're going to divide everything among the 3 kids. So just go divide everything among the 3 kids. And as long as everything gets distributed before that person dies, the assets are gone and there's no need for probate. Now, that's the only asset where that is not a good idea is if you have an asset that has appreciated in value, because there are some reasons why you want that to be in the probate estate. I'm going to talk about that in a few minutes. But otherwise, you can get rid of probate by simply getting things given away right before you die. And that way, you don't have to lose control of them now, right? As long as you trust the person who's got the power of attorney. You have to trust that person. The other way that you can do it, is with a trust. In Frank and Mary's case, they don't need a trust, which is why often couples will come in to me and say that they really want to structure a thing just for probate avoidance purposes. And I'll tell them you can do that, but you don't need to do that yet. If all of the assets are owned jointly, you really need to do that when there's only one of you left. Because at that point, if that one person dies, chances are there will be a probate unless you've dealt with probate with some kind of probate avoidance strategy. The trust that you would do in that case is a revocable and amendable trust. You've heard of always the difference between revocable and irrevocable trusts. A revocable trust is simply a trust where you can take the assets back. What a trust, we'll do 2 minutes on trust. So a trust is a relationship between two kinds of people. A trust isn't actually a separate legal entity, the way like a corporation is or a limited liability company. It just describes a relationship between two kinds of people. The trustee, who is the legal owner of the property as far as the rest of the world is concerned, and the beneficiary or beneficiaries. Because the trustee is the legal owner and is presumably buying and selling and dealing with this personal property for the benefit of that beneficiary, right? So if I decided that I wanted to just give you, Mr. Regier, if I wanted to give you $1,000 today, right? I could. And if I gave it to you and you took it, right? And I had the intention that that $1,000 was meant to be a gift, right? That it wasn't a loan, right? The moment that you got that property, if I turned around and said the next day, you know, I really need that $1,000 back, you wouldn't have to give it to me, right? Because legally, you became the owner of that property at the time that I did that. So in many cases, though, folks will say, well, you know, I really want to leave this money to my daughter, but, you know, she's got some problems or she's got credit or whatever, right? So instead, what I really want to do is I'll leave that money in trust for the benefit of my daughter. I'll give the money to somebody else who's going to be the legal controller of it, right? The trustee for the benefit of my daughter. Now, unless, and I can do that without even a writing. A trust does not require a writing, right? It's a lot better, right? But if I do that, unless there is a writing in which I specifically say, I'm putting this money into this trust irrevocably, I can always get the money back. If I create a revocable trust, what revocable means is that the money that I'm putting into trust, I can always take back out of trust, right? So in this case, Frank and Mary would do a revocable and amendable trust, meaning they can take any of it back anytime. They would say that they're both the trustees. If one of them dies, the other one becomes the sole trustee. But when the second one dies, two things would happen. One, somebody else would step in as the new trustee, typically one of the kids, the trusted child, the person that was going to be the executor or the personal representative under the estate. Secondly, at that moment, the trust becomes irrevocable because at that point, Frank and Mary are dead. So there's no one there that can revoke the trust. So then at that moment, the new trustee steps in and can take the assets and divide them up. So if in this case, all the assets were in trust, the two trustees, Frank and Mary, died and one of the kids became the new trustee, the day after the second parent dies, the new trustee can divide up all the money. There's no probate, there's no 1 year wait, there are no creditors. There were no creditors. So I had a family actually that had raised, I think there were 7 kids. And then they retired and they have a nice house and it's worth quite a bit. But one of their concerns was, in the course of all of this, you know, some of the kids went to law school and some of them went to art school, but all of them had student loans for which they co-signed. And so now they've got like $200,000 in remaining student loans. The lawyer paid it back, you know, but the artist is still kind of struggling. And so they're kind of worried about having to pay this stuff back. And their only big asset is their house. And I said, well, you know, if you put the house in trust, you name yourselves as the trustees and you specify that when the two of you are dead, one of you, the kids comes in as the successor trustee, they can just sell the house and divide up the money and the creditor goes away. Because the student loan company's claim only goes against the probate estate, right? A little known but interesting fact. So those are some of the reasons why you might want to do a revocable and amendable trust. But as I say, the most common time to do it is when you're single, is after one of you has died. Estate tax avoidance. So to understand how to avoid the estate tax, you need to understand a little bit about the estate tax. So here's a very short history of the Massachusetts estate tax. So Massachusetts estate tax, like most estate taxes, were created in like the 1920s, around the 1920s. The time was the Roaring 20s. You know, it's like now. You know, a lot of people made a lot of money, and there was some concern that, you know, why should it be that because somebody made a boatload of money, which, you know, they can have, they made the money, but why should it be because you were the lucky child of that person that made all that money, that you get to keep it all, even though everybody else who's working has to pay income tax? And that was kind of the premise behind the estate tax, that there'd be some amount that would be owed at death. And in Massachusetts, that happened, and an estate tax was adopted. And what they did was, they said, okay, if you die having above a particular amount of assets, we're going to consider that you're rich. And we're going to say that therefore a percentage of that is going to be paid in estate tax. And that number, which made you rich, was, take a guess how much that was in the mid-1920s. $40,000. So the chart that created the estate tax, well, you know, but my father bought his house. They bought their house in 1940 for $2,000. It's a 2-family house in Marlborough, Massachusetts for $2,000. And then my father, and they had a mortgage, which they had a tenant to help them pay the mortgage on the $2,000 house, right? That house sold about 4 years ago for $325,000. You know, things have changed. So the chart, the first $40,000 was free. Then from $40,000 to $90,000, the estate tax was like 0.8%. And then from 90 to like 140, it was like 1.6%. It was a graduated estate tax system. And so, and that chart, and there it is, it still exists. And it's still in effect. This chart is still in effect in Massachusetts right now, right? So your first 40,000 is free. 40 to 90 is 0.8%. 90 to 140 is 1.6, et cetera, et cetera. I'm not going to go through those. I just want you to go to the bottom. So the tax, according to that chart, on a taxable estate of $1 million is $36,560. The tax on Frank and Mary's estate, because they have $1,100,000, if it were all taxable, would be $42,640. Now, if either Frank or Mary dies and leaves everything to the surviving spouse, there is no estate tax. And the reason for that is the amount you give to your surviving spouse is a deduction from the taxable estate. So if Frank dies first, the taxable estate is $0. If Mary dies the next day, though, the taxable estate is $1,100,000, and according to the chart, that's the amount she would pay, $42,640. Now we're going to go back to some history. So about the 1950s, by that point, everybody's house values had gone up, and it turned out that the entire middle class was paying an estate tax when they died because if they owned a house, because everything was over $40,000. So folks went to the legislature and said, this is terrible, and legislators responded. They could have responded, excuse me, by amending the chart. That would have been the complicated thing to do, but instead they did the easy thing. Why could this have been? They did the easy thing. They simply changed the minimum. They said instead of the minimum being $40,000, it was going to go to $100,000. And then later it went to $300,000, and then it went to $600,000, and then it went to $1 million, and it's $1 million today. It became $1 million, I want to say in the late 1990s, if I recall correctly. So the minimum, so if you have an estate right now below $1 million, you pay no estate tax, which then leads to the question, but what if you have an estate that's $1 over, right? $1,001,001. What's the estate tax? Well, in many states, and I always use Rhode Island, I kind of pick on Rhode Island until about 3 or 4 years ago, they had an estate tax, same thing. They had a little chart, you know, and they had a minimum that kind of went up over time. And then, but the way theirs worked, it was referred to by many as a cliff tax. I think their magic number was like $650,000. If you had less than that, you paid no tax. If you had $650 and $1, you fell off the cliff and you owed the entire amount, right? That would have been owed under the chart, right? Massachusetts didn't do that, but they did want to phase out this benefit once you get to have more money. And so what they said was, whatever amount you have that is over this threshold amount, right? Which remember had gone up to 100, then 3, blah, 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 and now it's $1 million. We're going to have you compute your estate tax 2 ways. First, do the chart, right? Because it's still in effect. Second, compute the amount of tax that you would have paid if you were paying on all of the dollars over $1 million at 40%, 40. So if you have an estate here, a taxable estate of $1,001,001, you owe 40 cents. It's 40% of $1. If you have an estate of $1,100,000, you owe $40,000, right? So your marginal tax on that first 100,000 over $1 million is 40%. Now, even though according to the chart, see between like $1,040,000 and $1,540,000, the tax rate is only 6.4%, right? So the chart, according to the chart, your tax is only growing at like 6% per dollar, 6 cents on a dollar. According to this alternative, though, it's growing at 40 cents on a dollar. So in the case of Frank and Mary, remember their estate was $1.1 million. If Frank died, everything went to Mary, and then Mary died, right? This is how they would do the calculation, right? They'd say, according to the chart, the tax on $1,100,000 is $42,640. 40% of all the dollars over $1 million is $40,000. That's lower. So that's what they would owe in estate tax. For those of you who are curious, because you're seeing that kind of at some point these 2 lines are going to merge, right? That's sooner or later, 40% of the amount over $1 million is going to exceed the amount on the chart, and therefore you're going to go back to working on the chart. That number is around $125,000. So effectively, the rate of taxation on all your money between $1 million and about $1,125,000 is 40%. Then it drops to like 6, and then slowly goes up over time. So if you're Frank and Mary, and both have died, then the estate tax would be about $40,000. Now, the reason why that happens, when you think about it, is because when Frank died, he basically threw away his ability to give away $1 million, because instead he gave everything to Mary, right? If he had given it to anybody else, he could have given up to $1 million tax-free, right? Because any estate below $1 million is no tax, right? And so the standard estate tax avoidance mechanism for dealing with this is to say that when the first spouse dies, some amount of money goes into a trust, an estate tax avoidance trust. These are often referred to as A-B trusts. There are a bunch of terms for them. There's no magic one that's right. But conceptually, this is what is going on. When the first spouse dies, some of the money that would have gone directly to the surviving spouse instead goes in trust for the benefit of that surviving spouse. And in this case, because we're not talking about mass health, which we'll talk about in a second, in this case, the surviving spouse can actually be the trustee of the trust. So effectively, if Frank says, when I die, some amount of money is going to go into this trust for the benefit of Mary, but of course Mary's going to be the trustee and she can give herself as much as she wants. And the rest of it's going to go directly to Mary. And if by doing that, I make sure that when I die, say, of my $1,100,000, say $500,000 of it goes into this trust, which means Mary has only got $600,000 left. And if Mary dies the next day, her estate's going to be only $600,000, which is below $1 million. And when I died, this $500,000 that didn't go directly to Mary, but instead went into this trust and is therefore part of my taxable estate, was only $500,000. And that's less than $1 million too. And so like magic, the estate tax goes away, because now you've got two different estates, each of which is below $1 million. It is for that reason that basically if you have a total estate that's worth less than $2 million, you can basically eliminate the estate tax just by making sure that when the first spouse dies, up to $1 million that would have gone directly to the first spouse goes in trust for the benefit of the first spouse. That gets included in the first spouse's estate. If it's less than $1 million, there's no tax. By doing that, you reduce the second spouse's estate to only $1 million. So when she dies, there's no tax. That's how you avoid the estate tax. Finally, I want to talk a little bit about asset protection. Pretend now that you are Mary and Frank, and you're not 65 anymore. Now you're 80. You never thought it would happen, right? You never thought you'd really actually hit 80. So now you're 80. I remember my dad would always say, oh, to be 80 again. I remember telling a client that recently. He said, oh, to be 90 again, he said. So you never think it's going to happen. So anyway, say they're that age. They have a new worry now, right? Because they know about this. According to the Alzheimer's Association, if you're 65, your chances of getting a disease that causes dementia, 70% of those folks with dementia have got Alzheimer's, but also Parkinson's, a bunch of other things cause dementia. Even depression causes dementia. So stay happy, right? So if you're 65, your chances of ending up with a disease that causes dementia, having dementia, and needing to spend some time in a nursing home are 1 in 9. If you're 85, they're 1 in 3. How can this be? Well, because if you had anything else, if you had cancer, if you had a stroke or whatever, you're probably dead. So the pool of people has shrunk down, right? And most of the people, 85 or older, have kind of survived all that other stuff. And so they're kind of in this pool that they may be worried about having a memory problem. And the problem with having a memory problem, well, besides the personal problem of having a memory problem, is that Medicare isn't designed to take care of you in this case. Medicare pays for the cost of skilled care, not the cost of people to help you dress in the morning or make sure that you don't kind of, go outside and can't find your way home or all of those things. Medicare doesn't cover any of that. So if you're stuck needing a lot of care of that kind of care at home or needing nursing home care, you need to be paying for it privately unless you can qualify for mass health. Now, once again, pretend that these are Frank and Mary's assets and that they're both alive. In that case, even though they've got $1,100,000 in assets, if Mary needs to go to a nursing home, she can actually qualify for Mass Health fairly quickly. And once she does, her Social Security check, that $1,000 a month, will have to go to the nursing home, and Mass Health will pay all the rest. So how does she do that? Well, and by the way, this is what she's wanting to avoid. Actually, I think here our island home is a little more than $14,000 a month. But here's Mass Health 101. To qualify for Mass Health, Mary needs to show she has less than $2,000 in countable assets. Well, they got a lot more than that. Except that she's also got Frank. And Frank can own the house, no matter what the equity. You're in Nantucket, you got a house that you bought for very little 30 years ago, and now it's worth $2 million. That's okay. One spouse goes into the nursing home. We shift it to the other spouse. It's all safe. And remember one other thing. There is no look-back period. Everybody over 70 knows what look-back period means. There is no look-back period regarding spouses. So you can transfer your assets to your spouse the day before you apply for Mass Health. So Mary can own that, or if Mary goes into the nursing home, Frank can own the house. Frank can have other cash or cash equivalent assets equal to that amount, $126,420. Where do those numbers show up from? The sky. They just make them up, and every year it changes a little bit. This is like made up by the Center for Medicare and Medicaid. And it goes up a tiny amount with inflation every year. But most importantly, Frank can also have unlimited income. Unlimited income. So in Mary and Frank's situation, what they would do if Mary needed nursing home care is they'd shift all assets to Frank. Remember, there's no look back. Frank would keep up to $126,420 and then take the rest of the money and convert it from an asset, which is putting him over, Mary over asset because he's got too much, into an income stream because Frank can have unlimited income. So Frank would take the rest of the money and buy an annuity of a very specific kind. That annuity has to call for equal monthly payments over a term that is shorter than Frank's actuarial life expectancy. If Frank's 80 at this point, his life expectancy is around 10 years. The day after Frank buys the annuity, thereby reducing his remaining assets below the magic number, $126,420, Mary can qualify for Mass Health. So once again, going through these assets, Frank would keep the house. He'd need to convert this, he'd need to get Mary's money shifted to him. He'd need to convert his IRA and he'd have to cash out his annuity, unless that was an annuity that had the same characteristics I just told you. And that would be very rare. Most people have annuities that they can cash out right away, right? So he'd have to cash the annuity out. He could actually take his IRA or 401k money and convert it into one of these annuities without that triggering tax. The conversion from this pile of money to an income stream is not a taxable event. Frank will end up getting the money a little faster than he would have otherwise. If he had used, under the Social Security rules, he'd need to get the money by the time he was about 110. You know, those required minimum distributions? That's about the calculation it ends up being, that you get the money by the time you're 110. In Frank's case, he's going to get all the money over about 10 years, over the term of that annuity, so he's going to be paying tax a little faster. But that's an insignificant cost compared to the benefit of Mary qualifying for Mass Health, right? So the savings would all go into his name, Mary's money, and then he'd keep $100,000 and buy an annuity with the rest. You can have one or more annuities, right? So Mary can qualify for Mass Health while Frank is dead. The only possible problems, as I mentioned, regarding tax-deferred funds, you're going to need to, if those IRAs and 401ks were in Mary's name instead of Frank's name, she'd have to cash them out, pay the tax, give the money to Frank, and then Frank buys the annuity. So there may be a tax consequence. And there is a Mass Health regulation that started last year, which is really consistent with most other states, that says that if Frank does all this, and Mary goes on to Mass Health, and Mass Health is paying nursing home bills, and then Frank dies, before all of his annuity payments have come back, remember he used all that extra money to buy an annuity, Mass Health will have a lien on the remaining annuity payments. Not the ones that already got paid to him, but any payments that are remaining, which is the reason why in this kind of situation we would always encourage a client to buy a shorter annuity. The annuity can't be longer than Frank's actuarial life expectancy, which is about 10 years. It could be 3 years, though. It could be 4 years. It was until recently that in Massachusetts you couldn't buy one of these annuities less than 4 years. I just got a call like this week from there are several companies now that are fighting for this market that will now write an annuity for as short as, this one said 3 months, right? So once that restructuring has occurred, Mary can qualify. The only remaining issue is what happens if Frank dies now that he's got all these assets. Well, remember, Frank and Mary's original plan was, well, if I die, I want Mary to get everything. Well, we don't want that to happen, right? Mary's in a nursing home now. She gets all this money. She's going to get knocked off of Mass Health and have to spend it down before she can requalify for Mass Health. They can avoid that, though, by doing this, by changing their wills to say, if I, Frank, die, all of the assets that would have gone to Mary will instead go into trust for Mary's benefit. And in this case, you can name anybody as trustee. He just can't name Mary, as opposed to the estate tax minimization trust where he can name his spouse as the trustee. He can't name Mary, because Mary can't have the ability to use this money for her care. Otherwise, she'd have to use it for her care, right? The trust can say that the trustee has the right to distribute any amount of this money to the beneficiary, to Mary at any time for her care. But as long as he's not required in the trust to do so, Mass Health can't make him do it. And these funds are not lienable or accountable in the event that Mary needs to qualify for Mass Health. And then finally, the trust would say that following Frank's death, the remaining assets get divided up among the kids because there's no lien. I was going to talk about this case, but I'm running a little close on time, so I'm not going to. If you thought I talked too fast and want to see this again, first you can go on to Nantucket Cable TV, and thanks very much to the folks at Nantucket Cable TV for showing up. I appreciate it. Or you can go to Frank and Mary's YouTube channel, Elder Law Frank and Mary, where we have this and any of the other presentations that I've done, I think over the last 8 years. So if you really want to see me as I age, as I slowly age, what's kind of getting embarrassing now is that I'm starting to look more and more like Frank. It was different when I started this. So anyway, and remember, the goal of all of this is always to sleep well at night. If you're not worried about any of this stuff, well, then you don't have to do it. But if you are worried, at our age, the most important thing of life is get a good night's sleep. So if you're worried about it, you should talk to somebody about it. Thank you very much. Any questions on any of this? Yes, sir.
Just one. Any of those films that were made 8 years ago, are they not likely to be a little bit outdated?
They're going to be a little bit outdated. That's right. That's why we're pulling. Actually, it only goes back about 4 years now. I lie. But even those, we're trying to just update them. And I think what we're going to do also is increasingly, I'm doing, instead of forcing people to go through 30 minutes to figure out what they probably had a very specific question, I'm doing kind of on that same YouTube channel, I'm doing these clips, these 10-minute clips, trying to answer individual questions so that you don't have to get bored with everything else if you just want the answer to one question. Any other questions? Yes, sir.
Father, how do VA benefits factor into any of this at all?
How do VA benefits factor in? Well, if you are
the spouse is a veteran.
If the spouse is a veteran. So if there is a benefit, first of all, if the question is, can you, as a person with a memory problem, take advantage of going to the beds in a VA nursing home, right? Because there are some beds in VA nursing homes. The answer is only if you have, at this point, a service-related disability that's greater than 70%. That used to be much lower, and it's going to get much higher. It's going to go to 100 because over time, there haven't been any new beds built, VA beds. And that you can imagine the number of veterans in this age category is getting gigantic, right? Only other thing I'd mention is there is a benefit called the aid and attendance benefit, which is available to veterans who served during a period, who served at least 90 days in the service, where at least one of those days happened during a period of war. They don't have to have actually served in a war, right? Or served in the country, but it has to be boots on the ground, but it has to be during that period. And that benefit is really helpful, but not in these situations. It is helpful if you are going to an assisted living community, for example, and you can show that you need assistance with at least 2 of the activities of daily living, then that benefit, if you're the person with the disability, can give you up to $2,000 extra a month to pay for that assisted living community, right? and if you're the spouse, can give you up to $1,000 a month. The benefit also works well if you're staying at home, because the benefit can also be used to supplement your income in order to pay for a lot of home care, right? If you're in a nursing home, though, it will pay a nursing home benefit. It will pay that up to those amounts that I just gave you to the nursing home, but gets supplanted if you're on Mass Health. So usually the benefit of being on Mass Health is vastly greater than the VA benefit, and you can't get both. You can never get, okay, does that make sense? Okay. Any other questions? If not, thank you very much. And if you're single and you came to the wrong presentation, I'll be back here in April to talk about elder law for singles. Thank you.
Thank you.